Good morning. May it please the Court. Therese Savone on behalf of the appellant, Security First. I'd like to reserve 5 minutes for rebuttal.
And I'm sorry, what is your name again?
Therese Savone.
Very good. Thank you, ma'am.
Thank you. This case involves the use of a garnishment proceeding that resulted in 2 final judgments, when in reality, there should have only been 1. There was a final judgment in the underlying case that was entered by the trial court in December of 2016. The garnishment final judgment was entered in May of 2017. Now, there may be some disagreement about the facts between the parties, but those facts do not change the procedural issues that are at play here. The final garnishment judgment is void because it was entered when the amount due was sent to True Builders days prior. The denial then of Security's first motion to vacate that was filed pursuant to 1540 was error and calls for a reversal.
Let me zero in on one thing that the judge did that I want you to comment on that. When all these motions to vacate was heard before the court, and we have the transcript here, there was never a notice of appearance filed by the attorney in this case. And as I understand what the judge indicated, if you don't have a notice of appearance filed, that lawyer cannot file any pleading before the court. So in reality, what the court has done, I granted the temporary stay because I received this. She was not aware that there's been a failure to file a notice of appearance. So that kind of voided that whole request to set aside and so forth. I know you made quite an issue about that in your brief. Why isn't the trial court correct?
I think a notice of appearance does not always need to be filed, and I know in our brief we focused on some analogous cases where default cases, for example, and the reason is the factual premise of why notice of appearance wasn't required in this case was because there was extensive correspondence and communications between counsel for Security First and counsel for True Builders, and there was an understanding that the individual, even if they were not counsel of record, that they were the individual that True Builders was going through in order to make sure that the final judgment was satisfied and to work together to dissolve the writ of garnishment. I think the fact that a notice of appearance wasn't filed does not negate the Rule 1.540. Any party has the ability to file a 1.540 motion where a judgment is void or it's been satisfied, and that's exactly what we have here.
The facts of this case, I mean, this is very factual driven, and we're dealing with an issue, at least what was before the court. Here's this judgment that has been outstanding for quite a long time. And every time been a request, please pay, oh, we will. And at one point where the judge recognized that your clients were alerted, if we don't get it, we will be filing this writ of garnishment. And that was done 2 or 3 weeks before ultimately that was provided, to the court. And by the time they received the check, it was not for everything. So you're dealing with the facts, oh, don't worry, we'll get you. So finally, they become exacerbated. Enough. We're going to do the writ of garnishment. Suddenly, boom, everybody is on notice. Let's go ahead and clear this up. And then you have the added fact of an attorney who's not counsel of record files this, and then you're asking the court then to say, oh no, all that should be void. These circumstances are unique and such. How do you come to the conclusion that all that should be rendered void?
Sure, and the reason is simple, Your Honor. When we look at the facts, we look at the correspondences between the parties, it's clear that they were discussing the amounts and trying to pin down the amount of interest and the fees so that they could get a final payment that was to True Builders, that was owed to True Builders, and it's clear from the record that Security First was trying to do that in that May 2017 time period. When the other thing that's clear from the record is the fact that True Builders was notified that those checks were being overnighted to them. They were told, here are the checks, here are the copy of the checks, They are coming. Here's the FedEx tracking number. And that was May 26th of 2017. And the final garnishment judgment was entered May 30th of 2017. So True Builders was on notice that these monies were in fact coming. So
the problem is, though, they've been promised that so many times they couldn't take you seriously anymore. And the timeline that troubles me is that on May the 11th, counsel for True Builders told your client's counsel that if he did not receive payment by 3 p.m. the following day, he would file the motion for the final garnishment judgment. And in fact, what happened was you all received the checks from your client on May the 23rd, and you told counsel for True Builders, hey, we've got the checks. True Builders responds on May the 26th, says, a couple of weeks ago you promised me the checks would be sent. I still have not received them. That's why we submitted the final judgment of garnishment to the court. So you were on notice on May the 26th that they had submitted the judgment, and in fact they'd submitted it on the 19th. So finally the checks show up on the 30th of May, and it wasn't until sometime thereafter that you moved to vacate the judgment, indicating surprise. But we're told specifically on the 26th, we've already sent it. It's already gone. It's already, because we can't. You promised us and promised us and promised us. How long are people supposed to wait?
There are a few points I can touch on, Judge Morris. There was an email you indicated from May 11th that True Builders had said we're going to file the motion for final garnishment judgment, and that was sent at 2:43 in the afternoon. Earlier that morning, counsel for Security First had said, I am out of the country, I'm trying to work with you, and my client is out of the office this week. So True Builders knew, even though they're trying to work with them, there was no one there, and they were working even though they were outside of the office.
True Builders is dealing with a big law firm. You have one lawyer out of the country. That law firm's got a whole lot of lawyers. You know, I worked in a big law firm. That excuse never worked for me ever one time. I'm out of the country, I can't be there. They say, you got 100 lawyers in your Tampa office. That doesn't work. Get one of them down there.
I guess my point, Your Honor, is the fact that when we're talking about who is on notice of what, True Builders was on notice that this individual and the client was out. So even if we said, let's have another attorney from a different office, or the Tampa office, or the Miami office, let's have one of them jump on this case. The reality is, if they wanted to ensure those checks were going to be received by True Builders, we notified True Builders that Security First client was not in the office that week.
I am a little perplexed, though, by this whole action, because, in fact, the judgment was entered. When the money was received, it was satisfied. And yet you seek a vacation of the judgment, which seems to me distinctions with extremely small differences between vacating a judgment and getting a prompt satisfaction of judgment upon payment. And maybe that's outside of our record, maybe it's irrelevant, but I gotta tell you, I've been stumped by it. It's like, why are we here?
Well, and I think that's an excellent question, and I also, in tying in, I wanna say, when you mentioned that the vacation happened sometime later, the final garnishment judgment was entered May 30th. The motion to vacate under 1.540 was filed 1 month later.
That's
now,
a long
why?
time.
Sure, but when we have a 1.540 motion for being void, or for the fact that something was already previously satisfied, there is no time limit in that rule that says 30 days is outside of the window for a post-judgment relief. Why we are here today is there are rules in place that allow, there are statutes in place that say garnishment judgments are not allowed when there has been satisfaction. The checks had been sent by Security First to True Builders on May 26th. True Builders knew of that. The final garnishment judgment came several days later. So by the time that judgment was entered, and I don't know the specifics of the exact minute or second of when they were received by True Builders and when the final garnishment judgment was entered, but True Builders knew those checks were coming and had the FedEx tracking number on May 26th, days before the final garnishment judgment was entered. So we have monies that would satisfy the final judgment and the writ of garnishment. Those monies were sent, they were on their way. There was no question at that time. Then the trial court entered a final garnishment judgment when monies had already been paid. So because we have a garnishment judgment that is now in excess of what the judgment is, that's contrary to the garnishment statutes. So really, this is making sure that under 1540, the relief that's entitled to parties for post-judgment...
There was no effort by them to collect twice. They made no effort, zero. Instead, they filed a satisfaction.
So in the record, Your Honor, it does indicate that the garnishee, BB&T, called Securities First Counsel and indicated to them, hey, we received this judgment. And
given the track record in this case, maybe you should have had to make a few phone calls, because, boy, they sure made a whole bunch to you.
Your Honor, we can disagree on that, because I believe that there are phone calls more in the email showing that Security First Counsel was attempting to contact...
Did they ever collect one dime more than they were owed?
I do not believe so, and I will not...
Has your client been damaged in any way by the fact that this has been handled through a satisfaction of garnishment? Is there some quantifiable damage that's occurred?
Well, I think it's a policy argument, Your Honor, and the fact that you have a final garnishment judgment that is still on a record, and when we're talking about an insurance company, we're talking about companies that do business, naturally they do not want these types of judgment on their...
but that's not the question. I understand what they don't want and that it's out there, but is there anything of record where there's an actual tangible damage as a result?
I do not believe so, Your Honor, but this, again, going back to it, the statutes and the rules allow for this type of... And that in the policy standpoint, as we presented to the trial court, that there is a significant harm to Security First and other businesses when we have judgments that are out there, that in any type of algorithm, when they're looking at pulling in terms of the ratings of these companies, they're just going to look at the judgments out there. They're not going to look at the procedural and the factual nuances of a case to determine what really happened. The reality is there is a judgment out there that because the monies had already been paid to True Builders days prior, that is void as a matter of law, and a 1.540 motion is the appropriate remedy. Unless this court has any further questions, I'll reserve the rest of my time for rebuttal.
Very good. Thank you, ma'am.
May it please the court. This court has already addressed the critical issues. My name is Nick Shaneen, representing True Builders on an appeal of a non-final order where there are no damages. We just heard the concession. There are no damages. We heard the concession. There was no notice filed for this additional counsel to make these appearances, that all of the pleadings that they're talking about were actually nullities. And the thing that's critical about all of this is the entire time there was counsel of record, an attorney named Susan Payne, who had diligently been proceeding with the case during this entire period of time. And that counsel certainly had not just received the notice, as Judge Morris had indicated time and time again during the other conversations, but she had received the actual pleading of the May 19 tender of the final judgment for garnishment to the court. It was her duty, under her advocacy to her client, to inform her client, by the way, in case you really care this much about a final judgment of garnishment being entered, they filed it with the court May 19, 11 days before the court ultimately enters this final judgment. There is absolutely no question that they were on notice. They keep discussing the fact that that there's harm when there wasn't. There was no double recovery, as Judge Morris noted. There was not a single dime paid different than what would be paid. The judgment ultimately was $78,186.29. The amount paid, $78,186.29. If they were to somehow prevail on this appeal, the amount they would have paid is $78,186.29. There is no logical method by which we can get to the decision that the trial court erred when receiving these 13th hour efforts by the appellee, that she decided, A, you hadn't filed, you the counsel who filed these things, you weren't even the proper attorney, and you had counsel of record. And that's, of course, what makes the various default cases distinguishable. In a default circumstance where somebody's got a dialogue going, and then the other party surreptitiously rushes into court and files the default. Okay, that's a fundamentally different circumstance than one where there's a counsel of record who's being properly notified about things, and then another counsel says, hey, I want to file things too. The clerk of court needs to know Who's on first here? They need to know who's the proper party attorney, because we don't want the circumstance of interficious meddlers filing documents as though they can speak for a party when the party hasn't said, you do speak for me. The answer is simple. You file a notice of appearance and you proceed. None of that happened. Instead, we have a circumstance where the trial judge properly heard the matters, and when she did, she said, A, it's a nullity, and B, this has all been satisfied. There's nothing for me to do here. And C, this is important. If you did have an issue, you needed to notice me. You needed to object. Their counsel of record could have objected. As this court noted, they had been informed that this final judgment was coming in, and then on May 26th, there was an absolute communication to even this additional counsel, not Ms. Savona personally, but the attorney with her firm. And they could have absolutely said, oh, okay, now we finally understand. You were serious. After months and months of us telling you you're going to get paid and you didn't get paid, you were going to actually go and file this final judgment for a garnishment. That they could have picked up the phone, called the JA. They could have rushed in a motion. They could have filed a notice of appearance. They could have done lots of things. They did none of those things. So the idea that, oh, the check's in the mail counts as a reason that a trial judge errs in not vacating a satisfied judgment makes absolutely no sense. So I'll end with this, that an insurance company, particularly one who claims to be sensitive to entry of final judgments, knows that there are specific ways allowed by the rules of procedure to avoid those final judgments. The first is to pay the judgment, that you have 20 days per statute 627-4265 to pay that judgment. This has been 4 months, not 20 days. 2, you can timely file a motion for rehearing under 1530. Once that final judgment gets entered, you timely file a motion for rehearing, and that stops the clock for execution. The third is to file a timely notice of appeal within 30 days. If you do that, then you also need to follow it with a Rule 9310 motion for stay to prevent execution of the matter. But that is certainly a way to avoid a final judgment of garnishment. And then the last is a specific rule, clearly within the rules of civil procedure 1550B, which is a motion to stay execution. All those tools were available. They availed themselves of none of them, and instead they come now to this court attempting to cobble together an argument that which happened didn't happen sufficiently for their taste. You can't appeal that which isn't, and that is exactly what has been attempted here, and I thank the court for its attention to this matter, and on behalf of True Builders, I respectfully request this court to affirm in all manners. Thank you.
Very good. Thank you, Mr. Shannon. Okay. Ms. Bowen, you have your 5 minutes.
Thank you, Your Honor. Briefly, I know the issue of the notice of appearance was brought up by my colleague and by this court previously, and there is no record as to why a notice of appearance wasn't filed, but clearly there is a reason that it wasn't filed and that it needed to stay out. But this case turns on procedure. This case turns on the statute of garnishment, the post-judgment relief under 1.540, and to say that when a judgment is entered, when payment has already been sent, that ignores the statute and it ignores the rules that would allow for the vacation of a void judgment and of a judgment that has been satisfied. And for those reasons set forth today and for those in our brief, Security First respectfully requests this honorable court to reverse the trial court's order denying our motion to vacate with instructions to vacate the notice of voluntary dismissal, set aside the satisfaction of the garnishment judgment, vacate the garnishment judgment, and dismiss the writ of garnishment. Thank you, Your Honors.
Thank you. Thank you both.